On the lifting of the corporate veil in Irish company law. Maxims in Irish company law include that a company's assets and liabilities belong to the company itself. Shareholders and directors are not generally personally liable for a company's debts. However, the lifting of the corporate veil can be sanctioned by the courts where a shareholder and/or director, or pluralities thereof, are indeed personally liable for a company's debts or failings due to practice in the company. The case of Solomon and Solomon of 1897 held that the common law finds that there is a principle of corporate personality separate to the natural person. Directors of a company are not personally liable for the debts of a company. A properly incorporated company, therefore, is legally distinct from its owners. And this significance is such that a case such as this ensures that a company's liabilities remain with the company and they do not extend to shareholders or directors, save for where the corporate veil is lifted. In Ireland, there are statutory exceptions to such principles of separate legal entity. Fraudulent trading, per section 610 of the Companies Act, directs that directors knowingly carrying out fraudulent activities may be personally liable. Reckless trading, under 610 subsection 3 of the Companies Act, could direct that reckless trading of a company's affairs may render a director personally liable. Section 567 of where the Companies Act directs that where a director has made personal guarantee to a company's debt, they may be held liable. A failure to keep a proper book of account in Section 609 of the Companies Act directs that a director may be held liable for such conduct and the consequences thereof, where improper records are kept so as to prevent an accurate assessment of company affairs. This could be for the purposes of perhaps of securing extra lines of credit or appeasing an audit, internal, external, or for the purposes of obfuscating for some reason the company's ledgers. The abuse of a company name may render a director disqualified, and that restricted directors are prevented from using a company of a similarly sounding name so as to benefit from the established brand reputation and marketing efforts of the initial company from which they might have been restricted. Companies that operate as a sham per section 2 through 5 of the Act may involve the lifting of the veil of that company so as to make directors personally liable for the company's liabilities. Environmental violations, employment law breaches, tax evasion, and public interest grounds, such as for the protection of competition in the market and for that of the consumer, are all circumstances in which the courts may seek to, in the interest of public policy, pierce the corporate veil or lift the corporate veil. The Powers and Grey Mountain Management case of the Irish High Court in 2022 considers fraud and misrepresentation and found that the court may lift the veil where a company has defrauded its investors. The Jones and Lipman case of England found that a company set up to avoid legal obligations could be disregarded as having a separate legal entity, and therefore the directors could have been held personally liable in the event of such same similar circumstances happening in the common law. Guildford Motor Home and Horn, 1933, found that a former employee setting up a company so as to avoid a non-compete clause and therefore avoid a legal obligation may invite the intervention of the courts. In Cummings and Stewart, a company cannot be used to escape a contractual liability, and the setting up of same may cause the courts to dissolve such a company or indeed pierce the corporate veil so as to render a director and or shareholder personally liable for contractual liability. The public policy and justice aspects of piercing the corporate veil are considered in Dublin County Council and Elton Homes Limited, where the courts in Ireland directed that a company used to evade planning obligations may render the veil being lifted and assign direct personal liability for the company's liabilities to directors and or shareholders. The courts may disregard corporate responsibility to enforce compliance, as was the case in Dublin County Council and O'Riordan of 1985. Finally, the State and McInerney Company of Dublin County Council upheld the principle that corporate structures shall not defeat legal rights, and therefore legal rights shall triumph over that of corporate structures. A company cannot be used as a shield for the purposes of evading justice and or public policy. In DHN Food Distributors in Tower Hamlet, London Borough Council, the economic reality where companies operate as a single unit was recognised, and therefore group companies that operate nominally on paper as a group but in reality operate as a single unit shall be recognised by the courts and actions taken accordingly, should it be deemed necessary for the lifting of the corporate veil. In Allied Irish Coal Suppliers and Powell Dufresne International Fuels, the courts lifted in Ireland the corporate veil where corporate structures were creating legal unfairness. The court shall intervene to prevent the unjust enrichment and for the purposes of upholding equity. The Irish courts considered this in Dún Laoghaire Corporation and Park Hill Developments, where the courts directed that a company structure was being used unfairly and sanctioned a intervention by the courts to provide for personal liability for directors and or shareholders for the company's liabilities. In Fives plc and DCC, the 2009 cases heard in Ireland examined corporate wrongdoing in the context of shareholders' interests, and where shareholders' interests were found to have been wrongdoing, shareholders could be considered personally liable for the company's book debts. Group companies and parental liability. The Bugle Press Limited case of the 1960s enabled the common law to develop so as to refuse to allow minority oppression through artificial structures. Artificial structures being those structures established in the preparation and creation of a company for the purposes of oppression of a minority.